I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're turning our attention to the supports and services available to New Yorkers who face criminal charges but are ultimately found not guilty due to mental health conditions. And our guests are Garrett Smith, a statewide organizer at the Center for Community Alternatives. Welcome to the show, Garrett.
Thank you for having me, David.
Our pleasure. And we're also going to hear from Jayette Lansbury, a member of the New York State Criminal Justice Committee for the National Alliance on Mental Health. Thanks for making the time, Jayette.
I'm happy to be here.
Well, Jayette, I want to start with you because it's my understanding that your son has been in what's described as the quote-unquote forensic system for decades after he accepted what you've described as an insanity plea when facing criminal charges. Can you talk about what his experience has been like and what types of services and supports he's had access to while in this system?
It hasn't been easy because he went in quite young and he's still in there now, 30 years later. So it's been hard on the family because we've had a couple of losses that of people that were close to him since he's been in. And he didn't have the opportunity, especially with my mom, who he was very, very close with, to say the proper goodbye or to spend time with her before she passed. And I gotta admit, being the mom myself, it's been difficult. It does get overwhelming and depressing at times because it feels like I'm never going to get him out of the system. But it has fueled my fire for advocacy, not just for him, but for others as well that have mental health and other disabilities that land up in the system. And, we have hope that every 2 years that he's going to be transferred to a civil setting. And every 2 years we get the same decision of, no, we want to keep him another 2 years, a little bit more treatment. And, being things that have happened at night, you toss and turn because you can't find a solution to really turn this around. And that's why I started pushing, to write the FRA bill, the Forensic Rehabilitation Act, not only for him, but for others that are in the system, because I see what it does to him. I meet with other families. I talk to other families. And it's not right what's going on, to put it in a nutshell.
Well, yeah, Garrett, can you expand on what's happening in the forensic system, both from your own personal experience and what we're hearing about more broadly? And can you also just sort of paint a picture of what these settings are and what sort of services are available? Because I have to imagine for most people who, their only relationship to something like this is seeing it on Law and Order or in some other pop culture, really don't understand this world that people might enter.
Yeah. So it's very swept under the rug in New York State. The psychiatric centers are pretty much institutions like kind of hiding in plain sight, if so to speak. So when you look at it from the outside, it just looks like a hospital campus, it just looks like, campus grounds, the same way you would be, anywhere else, when you think of that type of physical space. But it's locked doors, and inside that hospital, a lot of patients who have the 330/20 CPL status, they say it's a 1 day to life sentence. And the reason for that is because there's no set time limit on when you are released or discharged back into the community. That's all subjective. It's all discretionary. And it's based on your treatment team and your psychiatrist. So that's the person who has the primary responsibility over how long you will be confined in the institution. And what their metric is so it's based on a rubric too, but what their metric primarily is they have a 6 month period first when you are first admitted. Again, this is after the court deems that you meet the not guilty due to mental disease and or defect. So you receive this status, and then based on this status, they will now determine what level of dangerousness your mental health condition has. So based on this, you will either go to a forensics, which means that you are Legally means you are suffering from a mental health condition that leads to imminent risk to yourself or others. Okay, so that would be a forensics level. If you are just suffering from a mental health condition where you're not is not to the level of dangerousness, you will go to an adult civil unit, long stay psychiatric facility. And if you are having a mental illness, but you're not suffering from it and it's not dangerous, you will be discharged or released to the community where you will go to an outpatient treatment for rehabilitation. So it's all based on recovery and rehabilitation, saying that during your instant offense, you were suffering from a mental illness. So you are not convicted of this crime, which means you're not going to prison, but you need help with your mental health condition and you need help with your recovery and rehabilitation. So the state will help you with that. Okay. So now you're going to the hospital with this. Okay. Now you're going to the hospital with this. First, there's a 6-month evaluation. Okay. Where they would determine what one of those three tracks that I mentioned
Hmm.
earlier, community, civil, or forensics. And they will do that through the courts. If you are determined where you're retained to, say, the forensics level, is then a 1 year retention, and then they'll reevaluate you again. After that, it's a 2 year retention and then it's every 2 years. And in that 2 year process, the hospital is going into agreement through the state with you as a patient that's receiving services from them. They're going into agreement through a treatment plan that these are the recovery and rehabilitative goals for you to hit, for you to be able to, move to the next level or transition, move your life forward, right? That's a contract that the hospital goes into with the patient. So the hospital has to, the treatment team has to sign it, the patient has to sign it, and it's to show that the hospital is helping this person recover from that state of the mental illness that they were suffering from before. The issue with this is that the plans are regurgitated, and you have to prove this through the courts that a person is recovered or have moved forward with their rehabilitation. If your medical records, if your treatment plans are the same treatment plans every 6 months, year after year, it is hard to quantify where you're recovering. So how can you show that as evidence of your recovery and show that as you're no longer a danger to yourself or others, you're no longer suffering from your mental illness. It looks like you're not progressing. So from a judge perspective who's not with you every day, who just sees you probably every 2 years, etc., they don't know that you're not progressing because of X, Y, and Z. They're just going based on the medical records, and the medical records shows that you're not progressing. And then you have that. So what happens with in the case of like Jayette's son, every 2 years he's being retained, and he's being retained because there's no way of quantifying his recovery. There's no way of quantifying through court evidence how this person is progressing. So they have to retain him because he still meets the dangerousness definition legally because of he's still in the same space. I hope that makes
Yeah.
sense. It's very is a very it's a hidden thing, in New York State. Not a lot of people know about what goes on with the psychiatric facilities and how a person can be sentenced to life without actually having a life sentence.
Well, yeah, I want to talk about sort of the legislative response to that dynamic you just outlined. And there's legislation that would place time limits on confinement under the situations you just described, equal to the minimum sentences, or 3 years in a secure facility and 6 years total in a secure or non-secure facility. And then also supposed to ensure decisions about the need for retention and mental health custody are driven by mental health clinicians and officials, as opposed to, say, prosecutors from that original case. Jay, when you think about the response to the status quo, what are some of the most important points that need to be considered for reform?
The important aspect, I got to say, number one, is that the fearless prosecutors take a step back because my son's been ordered out twice, and twice the prosecutors were able to step up and win an appeal. So that's number one. Number two is that a treatment team has to be more person-centered. They have to be also more transparent and have more accountability. That's not just for the treatment team, but for everybody in the system, all the clinicians and all the administration staff. Because, when families call up and they ask a question, we want an answer. We don't want to be told, no, you can't. And we need time limits. I mean, if my son would have took his regular charge and he would have survived being in prison, he would have did no more than 5 years. Here we are 30 years later, and he can't even get to the next step. To me, that's not right. He was offered 1.5 to 3 with no longer than 5. So 30 years does not equal that, not my arithmetic. So we definitely need time limits. We need the district attorney to take a step back. They do it in regular sentences. They can do it on a forensic sentence. They need to be transferred. They deserve to have a life. We need time limits, reasonable time limits. People that have done really horrific things, they're out. My son is still in for something half of that. Not that I'm condoning anybody, because trust me, in this fight, everybody's equal for our advocacy. Besides that, we need the accountability and the transparency. After the DAs, after time limits, we need the accountability, transparency. We need to be able to know what is going on, why they hold them, and we need for it to be person-centered. We need for them to be able to have a say-so in their treatment. We need for them to be able to speak their mind and say, this is what I want to do while I'm here, if it's going to groups or going to school. My son's been asking to get a peer specialist.
And after a quick break, we'll continue our conversation about the system that is in place to serve New Yorkers who plead not guilty to criminal charges because of mental health conditions. And when we return, we'll have more with Garrett Smith, a statewide organizer at the Center for Community Alternatives. But for now, we're going to say goodbye to Jayette Lansbury, a member of the New York State Criminal Justice Committee for the National Alliance on Mental Illness. Thanks for making the time, Jayette.
Thank you very much, David. I just want to say I'm in this fight till I see it changed, not only for him, but for others as well. I just wish that I would have known that he would survive if he went the other route, because I would have encouraged him to take the regular sentence. He would have been home and off supervision. I mean, now he's languishing his life away, in a secure facility where he's not getting treatment for both his OPWD as well as his mental illness, and he's not getting the supports to get him ready when he does return to society, which I gotta say, I hope is sooner than later.
Support for the Capitol Press Room comes from O'Donnell and Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com. I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're continuing our examination of the services and supports available in secured facilities for New Yorkers who face criminal charges but are ultimately found not guilty due to their mental health conditions. And we're continuing our conversation now with Garrett Smith, a statewide organizer at the Center for Community Alternatives, who's discussing legislation that would reform what is known as the forensic system in New York.
Can I say something towards that actually, that relates a lot to the person-centered approach that the legislation will have, that the Forensic Rehabilitation Act has as provisions. So one of the aspects that holds people up, where it feeds into that 1 day to life type of mind frame for patients, is The furloughs that are allotted to patients at the forensics level, at the civil and at the civil level, are not often utilized. And when they are utilized, they're underutilized. And that's due to multiple factors. Like one obvious factor that's used often is being short-staffed. Another is lack of like community connections to have like healthy furloughs, things of that nature. So it creates this limited environment. That's the reasons that they give. It could be multiple reasons, but for these reasons, it's not being provided. Now, furloughs, what that does is this. So for at the forensics level, what a furlough does, it shows that a person has an opportunity to utilize more freedom. So what they can do with more time in a less restricted environment. And it's going based on the Olmstead Act or the Olmstead decision, where it's you want to have the least restrictive environment for a person with along their rehabilitative and recovery progress, right? So at the forensics level, you can have escorted furloughs, like campus grounds furloughs. You can have escorted community furloughs. Now, what this can be is like, say, a person who has a history of, say, alcoholism or have a history of a drug addiction. They can attend AA or NA classes and or sessions in the community on an escorted furlough. Other escorted furloughs is a person can attend a PROS program, if you're familiar with PROS programs, but they're personalized recovery oriented services that the Office of Mental Health, they have them throughout multiple counties in New York State. So these are examples, but these are different types of opportunities. And then you have things like unescorted furloughs in the community, where a person can utilize that to get a job. For example, also under escorted community furloughs, a person can go to the YMCA, get a gym membership, things like that, affinity groups, joining things of that nature that helps them with their community and reintegration. They can also go to libraries to, they could learn the bus system, all of these different things that helps a person prepare for that next stage of their life when they're transitioning from confinement. The furloughs are not used. And then when they are used, they're underutilized. You have this. And even at the unescorted community furlough level, people can apply for a job. They can have a job in the community if they want, based on the hours that they're allotted. So it's all based on that person-centered approach, but having furloughs for each level of a person's transition being allotted to them. And it should be in time limits. It shouldn't be, withheld and held against them. And the reason why furloughs are so important is because that's a way for a person to quantify their recovery journey through their medical records, which then can be used within their court records when it's time for a retention hearing, a transfer hearing, a discharge hearing. Anytime they go into court, they can show their recovery in a quantifiable way. It's not just a qualitative thing, because they can show the number of opportunities that they partake in. They can track that. They can track the number of hours that they dedicated towards their recovery and their journey. They can also show those improvements through their treatment plans that will show a progression in their journey, where the judge can see all of that in all of these mitigating circumstances and see how this person has progressed. And they can make that decision whether to transfer them, release them, et cetera, based on that recovery. That's what this bill will do. It will strengthen the furlough process. It will also strengthen the way time limits are allotted. So it's not where a person is just perpetually retained. But just the last thing I want to say is that the Office of Mental Health has stated, they stated this publicly, they stated this in their records, that a person's recovery within a confined setting should be around 7 years. So around 7 years, or at the 7-year mark, if a person is still at one of these levels, say forensics, civil, or, forensics or civil setting, and on one of the furlough levels within one of these forensics or civil settings, they have to evaluate that and see what they are doing wrong. So if they're saying, hey, at the 7-year mark, if this person is still stuck at this level, we need to reevaluate what type of treatment we're doing.
Maybe we're the problem.
So yeah, and we're talking about people at 30 plus years. So all of that, just to really narrow it down, is really about time and the way that they're utilizing the time, in the way that they're holding people captive with that time.
Well, are there some people, though, for whom, if the services are available, if there are opportunities to try to integrate back into the world, where it's just not going to work for them, whether they are still going to present a danger to themselves or a danger to the public, even using the updated definition that this legislation proposes? And in those situations, what needs to happen? Is it okay for those people to remain in the secured facilities? I mean, are there always going to be some exceptions to this type of legislation and what we've been talking about?
I mean, it's almost like I don't mean to dismiss it, but it's almost
Sure.
like a straw man argument because it's looking at one for the many. So I always look at the system and reforms within the system and services, these type of safety nets within the system for people to be able to navigate their life, live their life with their family, et cetera, right? All these different liberties within the United States that we think of. Within this, if you look at removing certain safety nets because of one, you miss the thousands of people that are now held captive of this. So I always look at that. I always try to think of how many people are benefiting from this and how many people will help move their life forward versus like, yes, there will be this one person or this one situation. It's always going to be one situation for every law. So I always look at it as like, how impactful will this be? How many people will it help? And how will it impact the system where it will refine the system to be more efficient and more beneficial for the people? Because that's what it's supposed to be for. It's supposed to be for the people. So, I look at that. I look at the hundreds of people that are held within the system that are can live a full life. They meet the requirements. It's a study that's meet the gold standard within psychiatry, but it's called the Vermont Longitudinal Study by Courtney Harding. And it says if a person meets three of the four criteria based on having a serious mental health diagnosis, if they meet these three of the four recovery criteria, they are considered recovered from their mental illness. She did that study and found that there's 66% of the people met three out of four criteria for that. So what I'm trying to say with this, and longitudinal studies, of course, have to be over 20 plus years long, et cetera. So what I'm trying to say with this is that people do recover. The majority of people recover. And I'm talking about from a serious mental illness, not an access 2 diagnosis, but an access 1, which is, when we think of schizophrenia, bipolar, schizoaffective, those different mental illnesses, people recover from that. So to keep a person confined for 30 plus years for the rest of their life, it's contradictory to the Olmsted decision, it's contradictory to modern science. It just doesn't make much sense. And I look at it that way, where it's the amount of people it will help outweighs the type of one-offs type of situations of the what ifs.
Well, I want to follow up then because there's legislation that's pushed by Republican lawmakers here at the Capitol, and they want to ensure that if a person does end up avoiding, say, a guilty plea or a potential conviction by taking some sort of pleading some sort of mental defect or illness, that they would be held in a secured facility for something equal to the sentence of the imprisonment that they might have served. And they argue that this is beneficial both to the defendant and community at large because they have more quote unquote time in the mental health facility where they are guaranteed treatment for their disease, as well as having more time to gain skills to help them manage their disease. Does that seem to represent, I guess, a real disconnect with what's actually happening in these
Contradictory to
facilities?
the reality.
Yeah, can
It's
you
contradictory
expand
to
on
the
that?
reality happening in the facilities. Yes, it's one thing I just want to say, when a person receives a 33020 criminal procedure law status, they are not guilty of the crime that they're being charged of in the court of law. They're found not responsible for that due to the mental disease and or defect, which means that they need rehabilitation and recovery support. That's also why they retain their rights. As a person who's inpatient in a forensic setting can still vote, for example. You can still get your passport, for example. Those things are still available to that individual. So to keep a person confined indefinitely or confined for 25 years, 30 years is contradictory to the Olmsted decision, because now you're disregarding that person's ability for recovery and rehabilitation completely. You're now putting a time metric to it where you have to have this, even though you meet the standards for everything else, you still have this extra time. You're now just being warehoused in a facility. Human warehousing, that's not conducive for any society. And I just want to say with this too, you have to understand the most vulnerable people, most vulnerable New Yorkers are the ones who are confined for the longest of times. Right now, just even looking at the prisons, there's between 33 to 35,000 people currently in New York State prisons. The majority of them have either one, a mental health diagnosis, 2, a developmental disability, or 3, some form of history of a drug addiction or alcoholism, or a combination. That's the people who we're talking about who are in these confined spaces, the most vulnerable of New Yorkers, and the ones who will have the ability to have that rehabilitation, have that recovery, have that moment to move their life forward. It should be allotted to them. They shouldn't be these ways of holding them captive through time, because that's what it is. It's just holding them captive through time, no matter what they do to transform or transition their life.
Well, before I let you go, Garrett, I am hoping you can talk a little bit more about your experience. I mean, you navigated this process, but I have to imagine there were times when you felt hopeless and that this was not going to be a story where you would be in this position now
Yeah.
advocating for others. So what was it like trying to go through this system?
You had to be resilient. It was very difficult. Just to say too, the Forensic Rehabilitation Act, a lot of the provisions are things that I actually done when I was in the forensic setting, in the civil setting, and also in the community. So it's not a theory thing. It's something that was in practice. Also, other people who are 330/20s along with me in Rochester Psychiatric Center has done this as well. It's very daunting though. It's you can't, when you're in the hospital, everything that you do will be psychoanalyzed to the fullest extent. So if you laugh too much, that will be evaluated. If you cry about missing a family member's birthday or funeral, that will be evaluated. So you have to be very diligent and very on point about what you're doing. And I was very, proactive with mine because I have my wife, my son, my daughter, I have a family I needed to get back to. So I wasn't really there to waste time, so that helped me a lot with really understanding it. I had a really great lawyer as well that supported me through the process. So that helped me with a level of awareness of what I was getting myself into with understanding the system. But everything, when you think about the furloughs, everything that I mentioned, I applied all of that. Like when I had my escorted community furloughs, I used that to get a bank account, at ESL Community Bank at Federal Credit Union in Rochester to help with paying bills for my wife, help take care of my son, because I had a job, I had a job at the time. I was able to use the furloughs for that, but I was advocating heavy. I was seeing other patients who would have their treatment plan be the same objectives every 6 months, and I was just refusing to do that. But it takes resiliency, and not a lot of people have that. Some people do have it, but it's snatched from them. One of the main things that the hospital uses to get people to stay in compliance with what they're doing is chemical restraints. So it's a lot of over medication. There's a guy from Buffalo that was in the hospital with me at the same time in forensics, and he was on 4 times the therapeutic limit of Zyprexa. He was taking 16 milligrams a day. The therapeutic limit is like 4 or something like that. And he ballooned up within a year. He ballooned up over 100 pounds, and he had type 2 diabetes, and his cognitive abilities depreciated significantly. And this was in the first 2 years of him being in the hospital. He didn't get out of the forensics level until like almost like his 10th year or something like that. So it's very daunting, it's very scary, like you can be restrained. They can take your mind from you, man. Like it's not like it's hard to like explain it with the limited time that we have, but it's just really that, I had family advocates that would see me with my wife and my son, and on my one of my furlough visits, and they would kiss my wife on the cheek and say, "Hey, we're looking forward to your family being reunited." And then I hear the same family advocate is one of the people that's advocating for my retention. You get what I'm saying? It's scary, man. It's like it messes with you. That was one of the times I was most scared, where it's like, they could snatch the rug from under you when you think you're gonna, move your life forward, and you have your family on one end just waiting for you, and it's one day to life. You don't know when you're gonna get out. So just the last thing is just when I first got in, I was asking this doctor who was doing my evaluation. I asked him, I said, "Well, how long do you think I'll stay here?" And he said, "Well, Mr. Smith, you are a high functioning patient. You score pretty high on a global assessment function. And given your history and your level of family support, I believe you will get out of here in about 7 years." And he mean out of the forensics, so that's not including the civil setting. If I believed him, if I just gave in and I just said, "Hey, I'm gonna be a good patient and just take whatever medication you put in front of me," I wouldn't be here talking to you right now. I wouldn't have my family. I wouldn't have everything that I have now that I'm so blessed and grateful to have. I wouldn't have had that. And it's a lot of people that I know that are still stuck in the hospital. Like, I know them. I was there with them. Politicians who write these other bills, they can say what they want to say, but you can't disprove reality. You know what I mean? Like, and then I actually walked the path, and I seen it, and I done it, and I know that it works because I shared it with other patients who was in the hospital, and it worked for them too. So it's just a way to help more than just one person at a time. This bill will help thousands of people at a time, and even people after us, once it becomes law.
Well, unfortunately, that's all the time we have for this conversation. In the first half of the program, we heard from Jayette Lansbury of the National Alliance on Mental Illness, and we've just been hearing from Garrett Smith, a statewide organizer at the Center for Community Alternatives. Thank you, Garrett.
Yeah, no problem.
Thanks for listening to today's edition of the Capitol Press Room. For an insider take on what's happening in state government, check out our Dispatches from Planet Albany show, available wherever you get podcasts or at capitolpressroom.org.
Join us again for Capitol Press Room, a production of WCNY Connected, Syracuse.